Today, we're diving into what might be the most melodramatic legal filing since My Cousin Vinny became a courtroom strategy. That's right, folks, the entertainment world is ablaze with what we're calling the Baldoni brief, a legal document so dramatic it makes soap operas look understated. For those just tuning in, we're talking about the opposition to a motion to dismiss filed by actor-director Justin Baldoni and his team in their ongoing legal battle with publicist Leslie Sloane. Now we should clarify that we're not lawyers, but we've consulted with actual legal experts who have graciously translated this theatrical production into plain English for us. And what a production it is. The filing opens with a sentence so grandiose it deserves its own movie trailer. Allow me to perform a dramatic reading. The Sloane parties played an active and integral role in a conspiracy to inflict harm on the Wayfair parties. The conspirators first aimed to win plaintiff Blake Lively total control over the film. It ends with us by means of extortionate threats to go public with her baseless claims of sexual harassment. I'm sorry, but I need a moment to recover from the sheer intensity of Team Baldoni's prose. Why you collect yourself? Let's consult with our legal expert, who wishes to remain anonymous, but has been reviewing these filings. What's their take on this opening salvo? Well, they say legal filings are meant to present a case in the best light for a client. But this particular document pushes the boundaries of legal rhetoric. The language about conspirators and breadcrumbs of sinister allegations reads more like a thriller novel than a legal filing. Attorneys often aim to tell a compelling narrative, but the excessive dramatic language may actually undermine credibility with the court. So what the lawyers are saying is, they've turned "it ends with us" into "it begins with hyperbole." What I can say is that federal judges typically appreciate concise fact-based arguments rather than emotional appeals. Let's break down what's actually happening here. According to reporting and court documents, Baldoni directed "It Ends With Us," starring Blake Lively. There were apparently workplace issues, with Lively submitting a list of 17 concerns that she wanted addressed before continuing filming. And Baldoni's team is now claiming this was all part of an elaborate conspiracy orchestrated by Lively's publicist, Leslie Sloane, to destroy their reputations and, in their words, take their film from them. The irony is that in their own timeline document, they admit the only threat was Lively saying she might not promote the movie, which, let's be real, is a pretty standard negotiating tactic in Hollywood. I'm not going to use my star power to promote your project if I'm being treated poorly. Isn't exactly the plot of Ocean's 11. It's worth noting that when examining these claims, courts will look for specific evidence of wrongdoing by each defendant. One issue raised in the motion to dismiss is what's called group pleading, where plaintiffs lump all defendants together without specifying what each individual allegedly did wrong. And from what we understand, the Baldoni team's response to that criticism isn't particularly strong. The group pleading issue is a significant hurdle. Each defendant's alleged actions need to be clearly delineated, especially in defamation cases. Without specificity, courts often dismiss such claims. There's also this fascinating battle over which state's laws should apply. New York or California. Apparently this is crucial, because New York law is less favorable to Baldoni's claims. Yes, choice of law is critical here. Recent cases like Jacob versus Lawrence and Chinsey versus New York Times would be relevant precedents. But interestingly, the opposition doesn't address these cases directly. This omission could be problematic for their arguments. So they're essentially saying, we want California law because it works better for us? In essence, yes, but courts have established tests for determining which state's laws apply, and it's not simply about which is more favorable to the plaintiff. Let's talk about the remedy they're seeking. They've already amended their complaint once, but now they're asking for another chance if this gets dismissed. That's correct. The filing acknowledges they've already used their one-on-automatic amendment under Rule 1501, so they're now asking the court for permission to amend again if the motion succeeds. Courts often do grant one opportunity to amend, but given the PR-focused nature of previous filings, this could be a strategic move to keep the case in the public eye. Speaking of PR, it seems like Bryan Freedman, Baldoni's attorney, has a particular reputation for litigation by press, without commenting on any specific attorney. This approach is sometimes referred to as trying the case in the court of public opinion. While it may have PR value, judges generally don't look favorably on strategies that appear more focused on media attention than legal merit. And apparently Freedman is juggling several high-profile cases right now, including one involving reality TV stars that just had a major setback. Yes, there was a recent decision in an unrelated case involving Faith Stowers from Vanderpump Rules, where the court ruled that arbitration clauses in her contracts were valid. This means that case will proceed in private arbitration rather than public court, which is significant for an attorney who may prefer public litigation. What's fascinating is that in the hearing yesterday, the judge apparently got annoyed at some grandstanding comments. Judicial temperament varies, but most judges prioritize focused legal arguments over theatrical presentations. Making bold predictions about outcomes or excessive rhetorical flourishes can sometimes backfire. Yet this document includes statements like claims being unlikely to succeed. The very kind of language that reportedly annoyed the judge. Consistency in approach is generally advisable when appearing before the same judge. So what's the likely outcome here? Based on the information available, the motion to dismiss may well succeed, particularly on the group pleading issue. If New York law is applied, some claims may be dismissed outright. The court might grant leave to amend some claims, but others may be dismissed with prejudice if they're legally insufficient. In the meantime, it seems like Baldoni's strategy is to continue the PR campaign, mentioning concerned citizens in the country and beyond, supplying them with information. That language suggests they're preparing for further public-facing arguments. However, Lively's team has reportedly sought a gag order and sent cease and desist letters which could limit this approach. The most bewildering aspect of this whole saga is how Baldoni seems to be positioning himself as the victim, when by his own admission he's the one who chose to give up control of the film. It's giving "I'm going to take my ball and go home, and then see you for making me take my ball and go home" energy. One observer pointed out that Baldoni's father recently posted something described as a preposterous school bulletin board. The apple doesn't fall far from the tree, apparently, but seriously, this case highlights something important. Be out how defamation cases work. Indeed, to succeed in a defamation claim, plaintiffs must specifically identify false statements made by each defendant and demonstrate how those specific statements caused harm. Vague allegations of a smear campaign, without identifying particular false statements, are unlikely to survive legal scrutiny. Yet the filing repeatedly claims they have a mountain of evidence and overwhelming proof, without clearly presenting what that evidence actually is. That's often a red flag in legal arguments. Courts expect evidence to be clearly presented, not just alluded to. And apparently one of their smoking guns is Blake Lively promoting alcohol and hair products. Yes, apparently selling gin and hair care is now considered evidence of a conspiracy to defame, without commenting on the merits of specific allegations. Courts generally look for a clear causal connection between alleged wrongful actions and claimed damages. This whole situation reminds me of that Shakespeare line, "The lawyered off protest to much methinks." I'm pretty sure that's not the exact quote, but the sentiment fits. Before we wrap up, let's talk about what this means for Hollywood more broadly. Is this just another celebrity legal stat? Or does it reflect deeper industry issues? These kinds of disputes often highlight the tensions in creative collaborations and the complex power dynamics in entertainment. When creative differences escalate to legal action, it can reveal how contractual relationships sometimes fail to fully address the human elements of working together, and the implications of sexual harassment allegations in workplace settings continue to be a significant issue in Hollywood. How organizations respond to such allegations is critical. Best practices involve taking reports seriously, conducting thorough investigations, and implementing appropriate remedial measures, not retaliating against those who raise concerns. Well, listeners, we'll be keeping a close eye on this case as it unfolds. The next big date appears to be around March 20th, when Blake Lively's response to motions is due. That's our show for today. You know us too well. Until next time, I'm your host, reminding you that while justice may be blind, it can still roll its eyes at overly dramatic legal filings.